Hello, my name is Fahid Ali, and we are going to present the topics of contract law and corporation law. So here are my group members' name: Fahid Ali, myself, Jahangir Samad, and Waqar Saif Ahmed, and Ali Nawaz. Unfortunately, Ali Nawaz is not coming today. So we start. Part A: contract law. So Alex is a property developer who purchased a zonal land. So he is planning to develop 10 apartments. The planning certificate given to him by the city council did not mention that the land purchase was zoned as a residential. When his solicitor engaged into various activities, so he discovered the property was in fact classified as residential, which is contrary to the planning certificate. The issue here is to determine the rights Alex has against the vendor and the city issuing the planning certificate. So what the rules say? Under contract law, the use of misrepresentation in order to solicit the acceptance of a contract would negate the contract, and thus the innocent party would have the right to rescind the contract as laid down in the case Curtis versus Chemical Cleaning and Dyeing Co. in 1951. So there is another example of this rule. There is such a dispute relating to planning certificate was brought out by the court in Central Highland Regional Council versus Giju Party Limited. In this, the main issue was the liability of a city council which issues an incorrect planning certificate. When such a certificate was tendered to the third party, in this case, the court upheld the interpretation that if can be established that this third party would be dependent on the authenticity of the endorsement of such a certificate, then the city would owe a duty of care to such a person. So let's apply this rule in our case. The vendor provided Alex third party with an incorrect planning certificate, which ensured that Alex accepted the construction contract, thus following the pronouncements of the court in Curtis versus Chemical Cleaning and Dyeing would be deemed as soliciting agreement through misrepresentation. Furthermore, following the judgment laid down by the court in Central Highland Regional Council versus Giju Party Limited, we see that in this case where the parties to contract are depending on endorsement in planning certificate, so the council which is issuing such a certificate, in this scenario Alex commenced work on the project based on the endorsement of the planning certificate, and thus he was depending on such endorsement. Thus the city council owed a duty of care to ensure that a correct certificate was tendered. Resultantly, the city council was in breach of their obligations under such a duty of care. Now for the conclusion, I would like to invite Mr. Jahangir Samad.
Thank you, Fahd. Furthermore, I would like to conclude this. Basically, to conclude this, in the given set of facts and circumstances, Alex would have the right to rescind the contract if required. Furthermore, Alex would also be able to recover damages for the duty of breaches to him. Part B. First, we have to start with the issue. There are two corporate. The number one is Adam and Poe. They got the company known as Master Plate Private Limited. In order to commence a business, this business in the hospitality industry, and thus we have to enter into the various contracts with other entities for supplies and material requirement to run such establishment. Adam contracted with Irish Lane Limited to supply sheets of a particular quality to the company. This was affiliated pre-registration. At the time of the registration, however, this was not rectified by the company due to the various dispute between two companies, Adam and Poe. They are entering into the contract with the company in order to procure cutlery for the Masters Limited Private Limited. The contract was signed under the seal of Masters Plate Limited. The issue here is to determine the assumptions the cutlery company can make the liability for the payment of lien sheets. We have to apply rules on this one, and the rule is section 129(1) of the Corporation Act 2001 states that when dealing with such an officer, that third party can assume that the company constituted has been complying with the section 129. 2 says that the third party may assume that the person transacting does in fact that the authority to transact in such capacity. And the year is Miller 2015. This position has been ratified in the section of Freeman and Lockyer versus Buckhurst Park Properties, Mangle Limited, 1964, 2QB 480, McQueen 2016. And the rule, and the other rule is, and now I would like to invite my group member to conclude this summit. Thank you.
Hi, my name is Waqar Saif. I'm the other group member of this. So the other rule, when you look at here, the pre-registration contracts are normally governed by and regulated under the provision section of 131 of the Corporations Act 2001, bottomly 2016. This here, the company may ratify pre-registration contracts. After registration, once these contracts are ratified, they become contracts of the company, and thus the company would be liable for the debts and every debt that is arising from the same contract. However, as this provision of section 131 subsection 2 of the Corporation Act 2001, these pre-registration contracts, if they are not ratified by the company, they would be a debt on the individual that has been entered in the contract. And it's the same, the individual would be liable to pay for any debts or liabilities that have been arising from this contract. When we jump onto the application, if you see the result here in the company Master Private Limited, which my group member explained, that if when they did ratify the contract, Adam, who entered into the transaction on behalf of the company, he becomes liable for all the debts and liabilities that arose out of the contract. Not only the valid assumption which can be made by the third party, which was Poe, the other person who entered into the contract, had expressed the authority to enter in such a transaction. In this case, the Australian Securities and Investment Commission 5 Rich 2009, 75 ACSR 1 clarifies the same position of the law. And now when we jump into the conclusion, in this case, we could conclude that Adam would be liable to pay all sorts of debt that will be arising from this contract, as it was not ratified by the company. Such a contract would be cutlery company would be able to assume that Poe, the other person, has expressed authority to act on behalf of the company. Thank you so much, and thank you for for sir to giving us the opportunity to present this.